Hello class, and welcome to your Chapter 4 lecture where we're going to be discussing pretrial supervision, sentencing, as well as the pre-sentence investigation report. So let's jump into the learning objectives for this lesson. By the end, you should be able to distinguish the differences among pretrial release, pretrial supervision, and diversion, explain the factors that are involved in a decision whether to give pretrial release to a defendant from detention, understand how structured and unstructured sentencing affects judicial discretion, explain the purpose and contents of a PSI report, as well as to summarize the legal issues and criticisms of the PSI report. So let's look at pretrial services. So pretrial services is an agency that assists the court in deciding who they're going to release and who's going to be detained before their trial. This decision is made based on validated assessments and a pretrial interview with the defendant. So there are typically 4 case outcomes that you can have. The case is either dismissed, the offender is diverted from the court and from further conviction, you have a conviction by admission, or you have conviction through a trial. So pre-release here gives the defendant the opportunity to continue working and living in their community while they're awaiting a case determination, one of these 4. So let's look at the history of pretrial release. So being detained during the pretrial process was shown to be a disadvantage to the defendants during the sentencing outcome, which led to us using release as an option. So those who were incarcerated pre-trial, they're actually more likely to be sentenced to prison and be given lengthier sentences than those who were released pre-trial. The Manhattan Bail Project was the first time that we acknowledged that release was valuable and necessary for these defendants, that we couldn't simply keep detaining all of them. Then the Federal Bail Reform Act of 1966 gave us guidelines on bail amounts and alternatives to detention. So here the federal government made it known that release should be highly considered by the courts. And then the Bail Reform Act in 1984 said that we now need to make sure we're taking into account public safety concerns when we are releasing offenders. So we must take into account the threat that they pose to community safety in making that decision. So a study actually showed that low and medium risk offenders who were incarcerated pre-trial were 2 times more likely to reoffend after they were released from prison and served their sentence. Whereas high-risk offenders showed the same recidivism rates, whether they were detained or released pre-trial. So it shows you that there are negative consequences and that we could potentially be increasing recidivism by detaining low and moderate risk offenders pre-trial. So how do we make the decision to detain or to release? So the National Association of Pretrial Services Agencies actually gives standards that guide pretrial release and pretrial supervision. So they say that every arrestee should be considered for release, and the least restrictive option must be used, while making sure we're taking into account community safety and the likelihood of that offender to reappear for court. So we then have the Ohio Risk Assessment System, and you will be completing one of these for one of your assignments coming up, but they actually have a pretrial assessment tool as well. And this is a valid prediction of whether the offender is going to have a new arrest, as well as the possibility for them to fail to appear for the next court hearing. So in this way, in juvenile court, release is not dependent on offense severity in this way as it is in juvenile court. So in juvenile court, we do take into account on our risk assessment of whether to detain essentially pre-trial, we take into account the offense severity. That's not taken into account with the adults. So then we have the pretrial services risk assessment, which is a federal pretrial assessment, very similar to the ORAs that's used at the state level, and delegated release authority. So the delegated release authority simply is a term that is referring to the statutory authority that allows pretrial officers to release a defendant before that defendant sees the judge. So it gives them the authority to make that decision before the offender even sees the judge. So we have a couple different types of bonds that we can use when we're making these detain and release decisions. So a bond decision does take into account offense severity. Okay, so I want to be clear that whether to detain or release, it's not simply dependent on the offense severity. While it's a factor that's taken into account, it's not dependent on that. Now the type of bond is. So when we look at an unsecured bond, and you're going to want to know the difference between these four, an unsecured bond is where the defendant gives no money up front, but the whole amount becomes due if that offender fails to appear for their next court hearing. ROR is released on your own recognizance. This is simply a signed agreement that says the offender is going to appear for the next hearing. No collateral or money or anything is put up, just a signed agreement. You then have a secured bond where the defendant puts up full collateral for the full bail amount. It can either be cash or property that's put up as collateral, and this is going to be returned to the defendant when they do return for their next court hearing, so they get it back. A surety, however, is when the bond company is going to pay that full bail amount, and the defendant is going to pay roughly 15 to 20% of the bail amount to the bond company that's non-refundable. The bond company, though, will get the full amount back from the courts when that offender shows up for their next hearing. So we know from the text that more federal defendants are detained than our state defendants. So on average, 70% of federal offenders are detained, where at the state level it's roughly only 40%. So the reasons that they offer for why more federal defendants are possibly being detained is due to immigration. So more pretrial releasees in the federal system, they can't offer stable housing. They also may not be able to afford bail. We have racial disparities and even just a change in lifestyle. So some federal defendants they're finding are more transient. So they can't, again, offer a stable address that they can ensure, the courts can ensure that they're going to return to their next court hearing. So what are some solutions that we have to this? Well, the defendant has the right to have an attorney present at a bail hearing, but some defendants don't request to have one present. And the attorney there, if they are present, can present facts in favor of the defendant to help fully assure the courts that that defendant will return. They might think of things that the defendant would not think to say in that hearing. And then providing availability of information on bail options and bail bondsmen. So defendants don't have access to their phones while they're detained, so they may not have family phone numbers. They may not have memorized any phone numbers to call. And even if they call that family member, they may still not know how to go about obtaining a bail bondsman. So the argument is made that one solution to this problem is that we could provide the information to defendants in prison on the different bail options that there are, as well as phone numbers to contact bail bondsmen, give them their fees, as well as the methods of payments that they would be willing to collect. So let's get into pretrial supervision now. So pretrial supervision can be ordered as a condition of one of those bond methods. So the percentage of defendants that receive pretrial supervision is at 20% of state offenders and about 30% of federal offenders receive pretrial supervision. So they could be given conditions such as calling in weekly, having to follow a curfew, submit to drug testing, maintaining employment, not having contact with victims, witnesses, or co-defendants, maybe being placed on electronic monitoring. So those who are not in compliance, they'll typically be given a warning for the first time that they're not in compliance. If they continue to be non-compliant, they may have to report back to court, and the officer will give recommendations for additional conditions that should be put in place. And then lastly, if it was a very serious offense that they've maybe they were on the electronic monitor and they cut it off, then they'll issue a bench warrant. They might simply just detain that offender, or they could revoke their bail. So those who fail to appear typically are those who are younger, have substance abuse problems, have dropped out of high school, and have at least one failure to appear for a prior court hearing or escape from custody. So let's look at diversion. That was one of the options we talked about earlier. So this is an option during the pretrial process. It's essentially a deferred adjudication. So the offender is not going to be adjudicated on those charges or found guilty. Typically, it's offered to your low-risk offenders. And by doing this, the offender can not receive a criminal conviction, so they can avoid that. So typically it's after about 2 to 5 years, the charges will be dismissed, so long as they have no further police contact and no further charges. Now we get into sentencing. So sentencing is the post-conviction stage. After a defendant has been found guilty, they're now going to come before a judge for their formal sentencing. So being given a community sentence is based on whether the offender is eligible by law, which is based on their current offense that they're charged with, as well as their prior history. So they must take into account public safety in giving a community sentence, the ability to deter the offender from committing future crimes. Can we rehabilitate the offender? As well as looking at retribution and even reflective justice. So reflective justice is this interesting idea where the judge is going to take into account subjective extra-legal decision-making process, and they're going to engage in this where they're taking into account intangible factors. These are things such as how much media attention has the case gotten? Has the defendant been cooperative with the prosecution? What level or amount of harm was caused to the victim? And can they have the opportunity here to reduce oppression or systematic inequality? So no reflective justice, you'll want to know that. It's just that a judge taking into account things that aren't necessarily down on paper, but that they're going to be thinking about and considering while they're determining whether they're going to give a community sentence. So then we have structured and unstructured sentencing options that we're going to discuss. Structured sentencing examples include presumptive sentencing, the Sentencing Commission. We'll talk about the U.S. sentencing guidelines, as well as North Carolina sentencing guidelines. So the goal is to reduce sentencing disparity by using structured sentencing. So it provides judicial guidance and accountability according to the offense severity, as well as the prior record of that defendant. So it's just more consistent sentencing. So presumptive sentencing is where a judge may not deviate from predetermined narrow ranges without giving a written explanation as to why they diverted from that range. So this goes for prison sentences as well as for the offender's eligibility for a community sentence. Most states actually do cap their probation at around 5 years, but some states allow offenders to be on probation for 3 to 10 years. Looking at the Sentencing Commission, they actually monitor how sentencing guidelines and judicial departures are being used, and they then make sentencing recommendations to legislature so that we can make sure we're being consistent. So Pennsylvania uses a structured presumptive sentencing zones. So violent crimes essentially will get more time than nonviolent crimes. And again, it's just for consistency. Unfortunately, though, using structured sentencing does not give the judge much discretion, and it also doesn't allow them to really take into account other individual factors of that offender, because we're simply looking at the current offense and prior offense history in determining what range the judge needs to be within for that sentence. So U.S. sentencing guidelines are narrow and they're mandatory ranges, again, based on the offense, prior history, and also established facts. So in U.S. v. Booker, the court ruled that the obligation to enhance a sentence based on aggravating factors or aggravating facts was unconstitutional. 2 opinions later, though, the court said that the defendant, if they admit to those aggravating factors, or the prosecution can prove them beyond a reasonable doubt, then they can be used to aggravate the sentence up. Or if those guidelines are advisory rather than being mandatory. So saying that as long as they're simply saying that the judge can use this option, not that they have to use it, then it can be used. And by amending this decision two opinions later, it just gave judges more discretion again to be able to use those aggravating factors to mitigate up and down. And then North Carolina sentencing guidelines are important to touch on because they actually require that violent prisoners must serve 100% of their sentence. They also then have to serve an automatic 9 months of post-release supervision. They do, however, have options built in for community sentences for more classes of offenses that's built in right into their grid, so it offers greater eligibility for offenders to receive those community sentences. So now let's go on to unstructured sentencing. So unstructured sentencing is where the judge is going to decide the type of sentence, so prison or community sentence, and they're following very loose guidelines on the length of the sentence that they're going to give. So some laws do mandate prison for repeat offenders or certain violent crimes, but here the judges have much more discretion, and they're also able to take into account many more individualized factors of that individual when they're determining which sentence to give them. So the average time that's spent on probation under the unstructured sentencing guidelines are about 20 months for a misdemeanor offender and 33 months for a felony offender. All right, so we've talked about the different ways we can sentence an offender, whether we're giving them whether they have a structured or unstructured sentencing guideline that they're falling under, whether they're going to be given a community sentence, and what's looked at. Now let's look at the pre-sentence investigation report. So this is the report that's provided by the probation department prior to that sentencing decision being made. This report is used by the prosecution, it's used by the judge, as well as the defense and the probation departments when that offender then goes under supervision, or if that offender goes under supervision. So 64% of all felony cases typically will receive a PSI. Roughly 50% of states actually require this to be completed. 16 states it's discretionary, and in 10 states they don't exist. So we could do better in having consistency across our nation with these PSI reports. The purpose of the report is, one, to provide judges with timely, accurate information for sentencing. So this way, at the end of the report, the recommendation is going to give the judge the type of sentence that the offender could serve under whatever guidelines that state falls under. It also assists jails and prisons in the type of institutional programming that the offender should receive, because it gives so much information on the offender. Paroling authorities can also compare the defendant's version of the offense at the time of the arrest, because there's a section in the report where the officer will ask the defendant, give me your version. What happened? What was your culpability in this crime? And they actually give the offender's perspective. So the parole board can then use that to determine, has the offender actually been rehabilitated? Were they maybe not remorseful in the beginning and not taking responsibility for their actions? And now they are. So we have more confidence in releasing them on parole. It also assists in making community caseload assignments. So once the offender is, or if the offender is placed on community supervision, it gives their address. It'll give, so if it's a geographical, if the probation department is organized geographically, they would know where to assign that case. Similarly, if the offender is, say, a gang member, then it may go to a gang unit. If they have mental health needs, then the report will show that, and then we know to place that into a mental health caseload. So it helps to know where and which officer that offender would be best matched with. And then it also serves as a basis for writing the client treatment program plan, which you will also do in one of the upcoming weeks. So let's look at, what does the PSI contain? So the whole point of a PSI is to understand the causes of antisocial behavior, and also to clinically evaluate the potential for change that the offender has. So this report needs to be 3 things: factually accurate, objective, and verified. So factually accurate, the PSI officer needs to make sure that everything they're reporting in that report is a fact, that nothing is hearsay, nothing is I believe. It is simply facts. It must be objective, so again, no subjective or I think this about the offender. It needs to be objective. and verified. The PSI officer needs to make sure that they confirm all of the information they've received from either the offender or collateral contacts. So it's going to include information on the person's character, such as their personality and behavior. What external influences does that offender have? Are they married? Do they have family support? What was their culpability in that crime? Was anyone injured? If so, then the victim is able, for personal injury and burglary cases, they're actually able to submit a victim impact statement where they're going to give the physical, emotional, and financial toll that that crime took on them. And then we have their prior criminal history as well as the employment history. Does that offender hold a job? Are they able to hold a job? What's their education level like? So it includes all these different factors. So, in trying to gather all of that information, what does the PSI officer need to do? Well, they need to have great interviewing, investigating, and writing skills. So you need to be very talented here. So you need to be able to interview individuals, which is what you're going to do this week for your assignment. So you need to make sure that you're able to speak with someone and obtain information during a conversation. You have to have good investigating skills. You need to know who to go to, who to talk to, what questions to ask. And then writing skills. You need to be able to put all of that information together after you've gathered all of the facts, after you've verified all of the information you got. And you need to be able to present that in an organized and objective, straight to the point, concise, is a word we like to use, very concise report. So the interview and verification process. So the PSI officer is going to meet with an offender either in the probation office, they can meet with them at jail, or at their home. So the interview is going to interview these newly convicted offenders. They're going to collect information on their criminal history, again, education, employment, their family, any other relevant data that they see as necessary. So maybe mental and emotional health or physical health is important to include. They're going to interview collateral contacts, those being family, friends, the police, their employer if they have a job, and also the victim to gain their perspective and ensure that their voice is heard in this process. And they then need to make sure that they are verifying all of this information through either schools, their employers, looking at credit report services, because they're actually going to include in these PSI reports also how much money the offender makes, how much do they bring in, what's going to be their ability to pay their fines, costs, and possible restitution. So in essence, this report is going to give us a picture of the whole person rather than simply looking at, like we did in pre-trial, just looking at the offense and their prior criminal history. Now we want to know everything we possibly can about that person, what brought them to this point, and where do they currently stand. So then the PSI officer is going to make a sentencing recommendation. So the sentence recommendation is for the type of sentence, not the length. So in this way, when you're looking at structured guidelines, the PSI officer is going to say, okay, it falls in this range, and this is what the judge is able to sentence within. Or the judge can, or they'll note, the judge can give a jail sentence or a community sentence, or maybe the option is only for a jail sentence. They're going to include that on the PSI report at the end in the recommendation section, which there's an example in your book also to look at. So the recommendation is going to depend on, again, your sentencing guidelines and or your statutory equivalent and legal factors. So you're going to need to look at these different factors here. The criminal history, have they previously been under supervision? Do they have any pending cases awaiting an outcome? And what is the police accounts of the offense? So once we give that recommendation to the courts, they're going to then use that report and all the information obtained in it to make their recommendation. Again, if it's a structured sentence based off of the guidelines, if it's unstructured, then they'll be making it more individualized decision using all of that information that the PSI officer gave. So what are some legal issues that we have to consider in writing these PSI reports? So the Supreme Court actually ruled that there is no violation of due process when the PSI report is not disclosed to the defendant. However, some states do give the defendant the right to review that. So the federal system actually says that the defendant has to be given the option to review a PSI report at least 35 days before sentencing. And that gives the offender the opportunity to rebut any inconsistencies that they feel are found within that report. So I know in juvenile court, I've had that happen before where we don't hand out our reports to the youth. They can see it if they ask, but we typically say that they have to get it from their attorney. We don't provide that to them. And some attorneys will go over the information in that report. I will say that this more frequently happens with private attorneys or attorneys who are typically used to dealing with the adult criminal system because of these PSI reports. So they kind of equate it to a PSI report, which it is when we're coming in for disposition. But they critique it a lot more closely. I've had attorneys come to me in court and say, mom says that this information isn't correct or this is a little off. And it's just, we're not used to that in the juvenile system. But again, ours are the same way. It has to be factual, it has to be objective, and you have to make sure you verify all of the information that's in there. So when there's inaccuracies in the PSI report, is that legal grounds for the offender to be resentenced? So in the case I gave where I had an attorney come to me, it was a very minor inaccuracy that he had found. It was maybe a date was wrong, or the mom said I reported it, the offender's violation a little more harshly than she had described it. It was very minor. In the end, it was not going to affect the outcome of that hearing, so there was not an issue. Similar with these PSI reports. So inaccuracies can only be a grounds for resentencing if it is not due to a harmless error. However, if it would affect the sentencing outcome, then yes, it is legal grounds for resentencing. However, the defendant here has the burden of proof. Well, the defendant's attorney would hopefully argue that for them. So what about other rules of criminal procedure related to the PSI? So once convicted, any evidence that was obtained illegally, as well as hearsay, is now allowed to be put in that PSI report for the judge to consider for the sentencing decision. The Sixth Amendment also does not afford for a defendant to have their attorney present at the pre-sentence investigation while they're being interviewed. However, some states do allow for a defense attorney to indicate to that PSI officer what type of questions they may or may not ask. So once the offender goes to sentencing, the judge has considered all of these factors in this PSI report. Now the judge is going to consider what types of conditions they should be given under a community correction sentence, if that is in fact their sentence. So you have standard and special conditions. Know the difference between these two. So the judge here it's important to know that the judge is going to have the final say on which conditions the offender should be participating in or should be subjected to. Although the PSI officer will make some recommendations for conditions. Standard conditions include that the offender cannot commit new crimes, possess illegal substances, or associate with other criminals. It also could be that they must maintain employment and they must pay their fines and their restitution. Special conditions then include things such as the offender needing to participate in drug and alcohol counseling, parenting classes, general education or literacy classes, maybe some mental health treatment. So these special conditions are ones that are very specific to that offender's individualized needs, whereas standard conditions are rules that are set on nearly every offender. And then we have these interesting scarlet letter conditions. These aren't used very frequently, but these are conditions that are simply meant to invoke shame. It's the whole purpose. They want the offender to feel shameful for their actions. The important part, though, is that this is only done in close-knit communities, otherwise it's not effective. So in this way, the offender will be required to admit guilt to their community, who then shames them for those behaviors and those actions. But the important piece here that you have to remember is there must be a way for the offender to be welcomed back into that community. So after they're shamed by the community members, there has to be a means and a way for them to get back into the good graces of the community and to regain their trust. So this is typically used with your tribal nations, your ones that are more, again, close-knit communities. So, in sum, pretrial services include pretrial release as well as pretrial supervision. Risk assessment instruments are more fair and accurate at determining whether an offender should be released or not pending their trial. Defendants who are detained during pretrial are more likely to receive a prison sentence and a lengthier one at that. Pretrial supervision and bonds, the purpose is to ensure that the defendant appears for court and that they stay out of trouble while awaiting their next court hearing. Granting a community sentence, indeterminate sentencing, depends on the offense severity as well as the prior history. Indeterminate sentencing allows for consideration of more individual case factors than does determinate sentencing. Sentencing guidelines do reduce sentencing inequality. However, it's at the expense of losing judicial discretion. The PSI report aids judges, prosecution, the defense, as well as parole boards and probation. So it has many uses, not simply just for the judge at sentencing. And then finally, standard and special conditions can be ordered and placed onto an offender who is given a community sentence. So that was your Chapter 4 lecture. Don't forget there will be a PDF posted that you can review and follow as you're going along.